In the name of God, the compassionate, the merciful. Welcome, friends, to the 50th episode of Crime and Punishment, a legal podcast, not a political one, the official podcast of the Invictus Law Firm, PA, a criminal defense law firm in Orlando, Florida. The website for which is augustusinvictus.com, and that is me, yours truly, the host of this program. We are simulcasting to Twitch, DLive, Twitter, YouTube, LinkedIn. We've got a newsletter. We've got a viral style. I habitually forget to post these things, or at least to get the links before we go live. So do me a favor. Just go to twitter.com/EmperorInvictus and look on there. The links are on there. Don't do this to me. Just go sign up for the newsletter, please. And there you will also have the link to the viral style. Now, want to make sure the audio is doing well. Looks good on my side. Let me know if you cannot hear me. Well, if you can't hear me, you're not going to hear that. So let's just press ahead. For those who missed last week's program, we are reading one of my favorite books. In terms of legal philosophy, perhaps my favorite book of all time. It's called The Nomos of the Earth and the International Law of the Jus Publicum Europaeum by Carl Schmitt. Padfa says we are loud and clear. Very good. Carl Schmitt, a jurist, legal philosopher, happened to be Catholic. Most famous, however, or infamous for being a Nazi. They tried to prosecute him for war crimes after the Second World War. This, however, came out, I believe, in 1950. We went over this last week. Yeah, 1950. So 2 years after the infamous Nuremberg trials, which we have covered on this program already. He was not prosecuted. He came out with this 2 years later. So this time period between the end of World War II, the Nuremberg trials, and Schmitt's publication of The Nomos of the Earth, this is all around the time of Bretton Woods, of the establishment of the international order as we understand it today. The United Nations, European Union, its formation began in that period. Of course, it didn't start off as the European Union, but there were treaties being put in place that eventually led to the European Union as we know it today. NATO, World Trade Organization, this whole international structure, it did not exist before the conclusion of World War II. After World War II, that's when all of these treaties, all of these international bodies started being imposed on the world by those of us who won the Second World War, namely the United States, Russia, China, because we figured we might as well. They were the arch rival of Japan at the time. So it was us, Russia, China, Britain, France. And France, again, by sheer force of will of Charles de Gaulle. Because really it should have just been us and Russia and possibly Britain. We brought in France and China to kind of have our guys. And then that backfired, of course. But all be told, these 5 countries constitute the United Nations Security Council. We basically tell the UN what to do. We tell them what's what. And as Putin pointed out, when we don't think that the rest of the Security Council is going to go along with what we're going to do, we just do it without asking the Security Council. Namely, the Iraq invasion, right? We know that Russia's not going to greenlight this. We know that the rest of the Security Council is not going to work with us on this. So here's what we're going to do. We'll just invade Iraq and then take it to the UN as a fait accompli, and it's already done. No use crying over spilt milk. What do we do from here? Now that we've kicked in the door, hanged Saddam Hussein, now what do we do, United Nations? That is victor's justice. That is the imposition of an international order upon the world by the victors of the World War. That is the fruit of the Nuremberg trials. That is the fruit of Bretton Woods. This book was written at the beginning of all this. Again, 1950. Now, what we talked about last week was how Schmitt goes back to the ancient distinctions of law. the terrestrial world order, which includes land appropriations, boundary stones, the earth as the mother of law, and the sea, by contrast, as this wild, chaotic domain where no law can apply. It is a no man's land where pirates dwell. And of course, things like that change when you have the great sea powers, the Assyrians, the Cretans, the Greeks, the Carthaginians, the Romans, right? The British, when the British Empire came, and before them the Spanish, and after the British, USA, baby. These great sea powers impose a law of the seas upon the rest of the world. Now, let's read the last paragraph that we read last week, and then we will continue to the end of chapter 1. And I believe, considering my extensive off-the-cuff commentary, that should take us the rest of the program today. So the last paragraph from last week was thus: only when the great sea empires, maritime nations, or, to use a Greek expression, thalassocracies, arose was security and order established on the sea. The disturbers of the order created thereby sank to the level of common criminals. The pirate was declared to be an enemy of the human race. Hostis generis humani. You'll recall, in our discussion last week, piracy was just the way of things. You came upon a shore and you raided and you raped and plundered, and this was actually how you gained honor. This is the warrior life, and no better illustration of this than the Iliad and the Odyssey. All right, when Odysseus wins the Trojan War, he then goes home. First thing he does is stops at an island and raids the place. His men get drunk, fall asleep, and then the men of that island gather together and run them off, right? That was life back then. That was life until rather recently. As a matter of fact, you might recall this wonderful show called Vikings. The pirate used to be an esteemed warrior, but with the rise of sea powers that could impose an order upon the seas, pirates became criminals. And you see that pattern time and again. When you look at something like the United States criminal quote-unquote justice system, you see men of a certain temperament who are prone to fighting, men who are great when it comes to going to war. You see veterans coming home from war, and you see all of these men ostracized from the society they should be protecting. You see little kids, little boys specifically, who have a serious problem with the way, you know what, this is not a political program. We're not going to talk about politics. We're talking about the law. You see little boys going to school drawing a picture of the gun, and they get suspended. I remember one case, egregious case from years ago. A little boy, I believe in kindergarten, had a Pop-Tart and tore apart his Pop-Tart into the shape of a gun. Got suspended. This is what we do to masculinity in American law. That is the same thing that happens in the imposition of an order upon the sea by sea powers, but it also happens in land powers. And the overgrowth of American law, you see that same standard being applied across the board. Any man who shows a tendency toward aggressiveness, or even just the refusal to cow and lick boots, that person is now ostracized. That person is fast on the way to becoming an outlaw. Same thing with pirates. It used to be an honored thing to raid, to plunder, to wage war. It becomes outlawed when you have an order imposed by a greater power. This meant, oh, and by the way, in the case of piracy, they become an enemy of all humanity, right? Like communists should be. But pirates are declared an enemy of all humanity when a great sea power comes up, because those pirates, they hurt commerce, and they hurt the people who are under the protection of this empire. So in order to be an enemy of all humanity, what you really are is you are an enemy of the dominant power. The welfare of that power is the welfare of the people. This meant that he, that is the pirate, excuse me, that's an alarm we don't need, because I've cleared this hour for you, dear listener. This meant that he, that is the pirate, was ostracized and expelled, stripped of his rights, and made an outlaw by the rulers of the sea empires. Such extensions of law to the space of the free sea were world historical events of revolutionary significance. We will call them sea appropriations. The Assyrians, the Cretans, the Greeks, the Carthaginians, the Romans in the Mediterranean, the Hanseatics in the Baltic, and the British in the oceans of the world all appropriated the sea in this manner. As one English author said, quote, "The sea must be kept, the sea must be taken." However, sea appropriations became possible only at a later stage in the development of human means of power and human consciousness of space. That is how we ended the last program, so let's continue for the present program. By contrast, the great primeval acts of law remained terrestrial operations, appropriating land, founding cities, and establishing colonies. In Isidore of Seville's medieval definition in Etymologia, included in the first part of the famous, you know what, skip all that. In Isidore of Seville's medieval definition, the essence of international law is stated concretely. We'll skip the Latin, which literally means international law is land appropriation, building cities and fortifications, wars, captivity, bondage, return from captivity, alliances and peace treaties, armistice, inviolability of envoys, and prohibition of marriage with foreigners. Now, what did you hear in there about, I don't know, prison conditions? The flight of birds or hunting birds. The imposition of vaccinations. Not talking about present politics, talking about things that have happened in the past. None of that's in there, right? Until very, very recently. I mean, after 1948, the Nuremberg trials. That was what international law meant. Of the appropriation of land, building cities and fortifications, war. War was the obvious treaty in international law. The settlement of wars, how territory was going to be divided thereafter, what the terms of surrender were. This is what treaties meant. Now, treaties can mean anything. Cutting down global emissions, carbon footprints, I mean, anything that you hear coming out of the United Nations, it's all ideological, just garbage. Has nothing to do with legitimate international law. Land appropriation, going back to this medieval definition, land appropriation takes first place. The sea is not mentioned. In the Corpus Juris Justiniani, one finds similar definitions in which war, the diversity of peoples, empires, boundaries, and above all, trade and commerce are discussed in terms of the essence of international law. It would be worthwhile to compare and to consider historically the individual components of such definitions. At any rate, this would be more meaningful than the abstract definition of terms found in modern textbooks, which are geared to so-called norms. What synchronicity. I was having a conversation with a professor of law earlier today, in which we were discussing legal philosophy and the advent of positivism. And I was talking about how in law school, you only learn about H.L.A. Hart and his students. That's it. That is legal philosophy now. You don't talk about any other theory. You certainly, God forbid, you talk about natural law. Everything is positivism. And that's what he's talking about here. In modern textbooks, what is law? Law is just what you all come together and you agree upon and you put it down in writing and now bada bing. That's the law. The will of the people has been codified. That's what law is. Malarkey. Haberdashery. That is just absolutely not what law is. At least, not before 1948. Now, for the most concrete determination of what one calls international law, any medieval enumeration and listing of contents is illuminating even today, because appropriating land and founding cities always is associated with an initial measurement and distribution of usable soil, which produces a primary criterion embodying all subsequent criteria. It remains discernible as long as the structure remains recognizably the same. All subsequent legal relations to the soil, originally divided among the appropriating tribe or people, and all institutions of the walled city or of a new colony are determined by this primary criterion. You'll notice he's not talking about nomadic societies. He's not talking about the Bedouin in Arabia. He's talking about landed peoples. And he's talking about usable soil. We're talking about people who farm. Any place where you cannot farm, where the land does not produce, there's no flora, there's no what am I trying to say? Capacity for agriculture. This is wilderness. This is not habitable land. If you can't farm there, it's not usable land. It's not the subject of international law. It's wilderness, right? That's a very European way of looking at things. And that's kind of the point of this book. Up until 1948, you're talking about, and it's on the cover of the book, the Jus Publicum Europaeum, the public order of law that is European by nature. Post-1948, it becomes very globalist, and in recent times, far more recent times, in the past couple decades, especially with the decline of the American empire, Fareed Zakaria talking about the rise of the rest, and now, there's rising Asia, rising this, rising that, rising China, America's on the decline. All of this calls into question this European world order. Because even with the advent of Bretton Woods and the international order as we understand it today, it's still very European. Now, maybe we've had some serious novations, especially as concerns the law of war crimes. We have an imposition of a sea order, especially by the Americans after the fall of the Soviet Union. A lot of things to discuss there. But as far as habitable land, usable soil, all these things Schmidt is talking about, he's talking about European order. Explicitly so. When he talks about medieval textbooks in international law and medieval theories of international law, the very definition of medieval is European. This is absolutely a European world order, a European perspective on international law, a European Weltanschauung. Who cares what the Chinese say back in 1950, right? That is the world order he's coming from, and he's talking about the changing world order, how this is evolving now, especially with the coming to the frontier of outer space. That is as big a change in the game, or a potential to be so, as the discovery of the New World. Every autonomous and ontological judgment derives from the land, Schmidt says. For this reason, we will begin with land appropriation as the primeval act in founding law. A land appropriation grounds law in two directions, internally and externally. Internally, that is, within the land appropriating group, the first order of all ownership and property relations is created by the initial division and distribution of the land. Whether public or private, collective or individual or both, ownership derives from this initial land division. Whether or not cadastral surveys are undertaken and land registers are established are later questions, and they concern distinctions presupposed by and derived from the common act of land appropriation. In historical reality, every imaginable possibility and combination of legal and property titles abound. But even when the initial land division establishes purely individualistic private ownership or common clan ownership, this form of property remains dependent on the common land appropriation and derives legally from the common primeval act. To this extent, every land appropriation internally creates a kind of supreme ownership of the community as a whole, even if the subsequent distribution of property does not remain purely communal and recognizes completely free private ownership of the individual. I can hear all of you who are libertarians salivating right now, but we are not talking about politics. Oh, good point, Chase. Chase points out the creation of Israel was also about that time, 1948. So, the creation of Israel, the Nuremberg trials, Bretton Woods, the coming together of the European Union, the writing of this book, that was all in the same 2 or 3 year period. World-changing events back then. Padfa says privateers were sanctioned and raised by the crown, where convenient, and they were getting their cut, of course. Yeah, very true. Privateers is a very charitable word for pirates. The Sir Francis Drake, pretty sure, was like an actual pirate, very honored. And, of course, he was in league with the crown, going around raiding villages and looting and raiding, all that stuff. He gives his share to the crown, and he's sanctioned by the government. Of course, contractors in Iraq and Afghanistan is perfectly permissible nowadays, says Padfa. Schmidt says, Chase, Schmidt is definitely not talked about. He can get you blacklisted if written about in certain universities. Yeah, but you know what's interesting? In Europe, at least, a lot of the people talking about Schmidt, actually, I guess no one in America talks about him, so there's that. But in Europe, the people who do talk about Schmidt in the university setting, in academia, they all happen to be leftists. Except, of course, the Nouvelle Droite, the New Right, the European New Right, not the Jack Posobiec, Mike Cernovich kind, but the actual New Right was obviously wholly dependent, I would say, upon Schmidt's work. But usually it's actually leftists talking about Schmidt. You just cannot deny that Schmidt was right about basically everything. Hey, Richard is here. Richard Heathen. How is it going, man? It was Richard. You can all thank Richard for this episode because Richard left a comment on the last episode saying that he prefers this content to the outrage content of usual legal podcasts talking about the news and stuff. So I figured we might as well just finish chapter 1, keep going with this book. Like I said, this is my favorite book in legal philosophy. Padfa says the universities are hopelessly compromised now. Yep, it's another thing I was talking about with the professor this afternoon. They certainly are. Don't know how to fix that. But then again, I'm not a law professor. I am your professor of lawfare here on Crime and Punishment. All of those things at once, what a coincidence, says Ulfric, about creation of Israel, the creation of Bretton Woods, coming together, European Union, all of that at the same time. Super coincidental. Now, Kiernan says, it's been far too long since I've been able to join you live. A couple years. Well, I guess everything works out, man. We are late to today's program, so maybe that's why. Usually we go live at 3. Had a lot going on today. Let's continue, shall we? Got a few more pages here. Externally, the land appropriating group is confronted with other land appropriating or land owning groups and powers. In this case, land appropriation represents a legal title in international law in 2 different ways. Either a parcel of land is extracted from a space that until then had been considered to be free, that is, having no owner or master recognized by the foreign law of the land appropriating group, or a parcel of land is extracted from a formally recognized owner and master, and thereby becomes the property of the new owner and master. Like when the Rhineland switches from Germany to France, or the Danzig switches from Germany to Poland, right? It is not difficult to comprehend that acquisition of formerly free territory, lacking any owner or master, presents, the New World, arguably. Although, could say that the Indians who didn't believe in land ownership did own the land, but that's a debate for another time, perhaps. It is not difficult to comprehend that acquisition of formerly free territory, lacking any owner or master, presents a different and simpler legal problem than does acquisition of territory with recognized ownership. In every case, land appropriation, both internally and externally, is the primary legal title that underlies all subsequent law. Territorial law and territorial succession, militia, and the National Guard presuppose land appropriation. That's a huge statement that we probably shouldn't just skip over. In every case, land appropriation, both internally and externally, is the primary legal title that underlies all subsequent law. So without land appropriation, without your ownership of the land, there is no law. All law comes from you having ownership of that land, jurisdiction, right? Territorial law, territorial succession, militia, National Guard, these all presuppose land appropriation. You have an army. You have a police force. Obviously, you have to control that land. You have to have legal title of that land to be sending out these troops. Taxation. You have to have control over that land in order to tax the people inside of that land. Land appropriation also precedes the distinction between private and public law. In general, it creates the conditions for this distinction. To this extent, from a legal perspective, one might say that land appropriation has a categorical character. Kant expounds on this notion with great clarity in his philosophy of law. Interesting that Schmidt would be quoting Kant, who is a fellow German, but is also an Enlightenment philosopher. In sharp contrast with the natural law, the natural law outlook of Schmidt, who is also Catholic. Kant expounds on this notion with great clarity in his philosophy of law. He speaks of territorial sovereignty, or more preferably of supreme proprietorship of the soil, which he considers to be the main condition for the possibility of ownership in all further law, public as well as private. Of course, he construes this completely ahistorically, as a purely logical idea of the civil constitution. Also, it seems to me, that is Schmidt, not me, that neither of his terms, that is, neither of Kant's terms, supreme proprietorship and territorial sovereignty, is entirely useful for our discussion, since they are determined too much by the distinction between public and private law. So he's saying, yeah, Kant might be ridiculous, and maybe he's completely ahistorical, and he's trying to pull these abstract ideas out of nowhere, and, nothing he says has substance. However, even that guy who had things so dramatically wrong, even he would agree that all law comes from supreme territorial ownership, from territorial sovereignty, supreme proprietorship. So even the guy who disagrees with me about everything, even that guy agrees that all law comes from land ownership. Today, most jurists understand supreme proprietorship only as property, and then only in the sense of private law, whereas territorial sovereignty is understood as public power and domination, imperium. So here he is making the distinction between dominium and imperium. Supreme proprietorship as property, that is dominium, and territorial sovereignty, which is public power and domination, the Latin for which is imperium. But there are two aspects to this distinction. First, we must not think of land appropriation as a purely intellectual construct, but must consider it to be a legal fact, to be a great historical event even if historically land appropriation proceeded rather tumultuously, and, at times, the right to land arose from overflowing migrations of peoples and campaigns of conquest, and, at other times, from successful defense of a country against foreigners. So that is a supreme distinction to make, right? This is about an historical fact. This is not an intellectual construct like the rule of law, or the categorical imperative, or utilitarianism, anything else you might think of in the world of philosophy. What he's talking about is a very concrete thing. We have gone to war, and we have taken over your territory. We have appropriated your land into our land. Now this belongs to our empire, our kingdom. That is an historical fact. We went to war and we took your land. That is the basis of law. It's a concrete thing. It's not intellectual at all. You know, while we're on the subject, we got a little time. I would point out this is one of the things Bishop Barron talks about as far as Christianity is concerned. Yes, there are certainly a lot of historical and theological and whatever other allogicals you want to add in there, similarities between Christianity and paganism, or Christianity and Buddhism, or any other religion. However, you can talk about Buddhism as this construct of abstract principles and meditations and practices, the eightfold path. Doesn't depend on anything historical, necessarily. You could take Buddha completely out of the picture and it wouldn't matter. It's the speech of Buddha that matters. Take a lot of paganism. Perhaps it is the case that Dionysus was a real person. Maybe he did some things and they passed into legend and got blown out of proportion. Who knows? Maybe Hercules was a real person. Maybe these stories were based on real incidents. Maybe Osiris and Isis and Horus were all real people. And they had things attributed to them. Who knows? But we don't care, right? In paganism, there's a mythological force behind it. It doesn't have to be real. It doesn't have to be historical. Catholicism absolutely must be historical. It depends on an historical fact. All of the intellectual concepts or theology or whatever else about Catholicism, it all is meaningless unless there was an historical event of the crucifixion and the resurrection. That is the same distinction that Schmidt is making about international law, or about all law. All law comes down to an historical event of land appropriation. All of your jurisprudential theories, all of your intellectualism, all of your quibbling about positivism versus whatever other radical new legal philosophy you've got, it's all meaningless unless there's been a land appropriation of some sort. You have taken over free land, or you have appropriated land from the former owner of it. That is the only basis of law, is this historical fact. So again, some radical statements here. In every case, land appropriation is the primary legal title that underlies all subsequent law. That's how he started this paragraph. Then he says, we must not think of land appropriation as a purely intellectual construct, but must consider it to be a legal fact, to be a great historical event, even if historically land appropriation proceeded rather tumultuously. It is an historical fact, not an intellectual construct. Second, to continue here, we must remember that, both externally and internally, this fundamental process of land appropriation preceded the distinction between public and private law, public authority and private property, imperium and dominium. Land appropriation thus is the archetype of a constitutive legal process externally, vis-a-vis other people, and internally, for the ordering of land and property within a country. It creates the most radical legal title, in the full and comprehensive sense of the term radical title. This terrestrial fundament, in which all law is rooted, in which space and law, order and orientation meet, was recognized by the great legal philosophers. The first law, said Giambattista Vico, was received by men from heroes in the form of the first agrarian laws. For Vico, the division and demarcation of soil is, along with religion, marriage, and asylum, one of the four primeval elements of all human law and all human history. So Schmidt's argument is everything comes down to land appropriation. Ownership of the land, supreme territorial sovereignty of the land, or supreme proprietorship. You can tell I did not prepare for this episode at all. Anyway, that's what it all comes down to for Schmidt. Supreme ownership of the land, right? For Giambattista Vico, he's saying that there are four primeval elements of all human law and human history. These four primeval things are the demarcation of soil, marriage, asylum, and religion. That's it. All law, all human endeavor, all human history, everything about human society, it comes down to those four things. Demarcation of soil, marriage, asylum, religion. That's it. The whole of human experience is summed up in that. To avoid giving the impression that we are dealing merely with mythological legal antiquities, I will cite two more recent modern legal philosophers, John Locke and Immanuel Kant. Again, two very unlikely sources for the Catholic Nazi, Carl Schmitt, right? Kant and Locke are famously the foundation of a lot of liberalism. Much of the theory, much of our country, much of the international order. I mean, all of the international order really is based on those two guys, especially Kant, who famously said that democracies don't go to war with each other. That's why everybody should be a democracy, and that's why we should bomb democracy into Iraq and Afghanistan and anyone else who disagrees with the international order, because democracies don't go to war. Once everybody's a democracy, according to this Kantian philosophy, there will be no more war. Be no more need for it. We'll all vote on everything, right? So, super uncharacteristic, perhaps, things to base his opinion on. But again, he's saying even these guys agree with me. So according to Locke, the essence of political power, first and foremost, is jurisdiction over the land. He understands jurisdiction in medieval terms, as sovereignty and dominion in general. For Locke, the occupation of a country is subjugation by whoever has jurisdiction over the soil. Domination is, first of all, rule only over the land, and only as a consequence of this, rule over the people who live on it. Even in this purely theoretical legal philosophical formulation, the aftermath of the Norman conquest of England by William the Conqueror still is recognizable. The Englishman, Locke, often described as a modern rationalist, in reality still is rooted deeply in the tradition of the medieval feudal land law that resulted from the fundamental legal process of the Norman land appropriation. Well, let's unpack that before we move to Kant. 1066 AD, William the Conqueror conquers England. They are Norman invaders. This is where the common law comes from. And we've discussed this on the show multiple times, so crash course for all those who are new to the program. They get there, and there's already a law in place. So they do have their Norman laws that they're going to impose on England, the conquered territory. But they also keep in place local laws. So for instance, if someone stole a pig, and that pig is worth a farthing, I don't know anything about English currency, so forgive me, but if that pig is worth a farthing, somebody steals a pig and they said, okay, well, you owe him 2 farthings now because you're going to pay him compensatory damages and we're going to impose punitive damages because you shouldn't have done that. Well, in the next case where someone steals a pig of like size and age and quality, well, that person's going to owe 2 farthings as well. That is case precedent. So the Normans under William, they left that in place. while creating this other system of law. Locke is a product of that. Just like I am a product of our Anglo-American tradition or any other American lawyer right now. We are all products of this system, right? Locke cannot escape being an Englishman, the heir of William of Normandy, William the Conqueror, and everybody who came after him. So for Locke, with as liberal as he is, even he believes in this medieval theory that all law comes from land appropriation, which is Schmitt's argument. Look at these liberals, and even they believe that law comes from land appropriation. However, as is evident in Kant's doctrine of the supreme proprietorship of the land, in Philosophical Fundamentals, his legal theory also begins with the premise that all property and every legal order has land as its precondition and is derived from the original acquisition of the earth's soil. Kant says, first acquisition of a thing can be only acquisition of land. This law of mine and thine that distributes the land to each man, as he put it, is not positive law in the sense of later state codifications or the system of legality in subsequent state constitutions. It is and remains the real core of a wholly concrete historical and political event, a land appropriation. You don't really need that now, do you? We're talking, what year is it? We're talking about 72 years later, 72 years after this book was written. Do you need land in order to make laws? Technically, yes. You know, some people are confused about Biden's executive orders, for instance, and we take no position on Biden because we have no political opinions here on Crime and Punishment. We love whoever's in charge, especially whoever is in charge of YouTube. Biden will issue these proclamations like, you've got to wear masks. All of these companies have to have their employees vaccinated. Well, he only has jurisdiction over certain things, right? Like places where there is federal land. He can't just impose a mask mandate on, say, Orange County, Florida, but he can impose a mask mandate on federal property in Orange County, Florida. So we still, to this day, even with all of this insanity about we can just make up whatever laws we want and people can vote on them and, you know, you could make up laws out of thin air. Well, actually you can't. Even now, those laws have to be rooted in land. You have to have some kind of jurisdiction. Even when there's an American citizen who, say, lives in Japan, well, he's still subject to United States taxation laws because he's an American citizen. That taxation law is rooted in the land because the federal government has jurisdiction over the land of the United States of America. And if you are a citizen of the United States, you are subject to the laws of that land, a very concrete thing. We appropriated this land. It is our land. We have the right by God to make laws. And those laws include taxation. And they will apply to you whether you are physically present on our land or you are one of our people tied to our land who is halfway across the world. No matter which way you cut it, it all comes back to we have power over this land. We own it. And therefore, we make the laws. So all of this abstraction that we see, especially in the last 72 years since this book was written, or the 80 years since the end of World War II, the construction of all this international order, even with all of this abstract, well, let's do this treaty and that treaty with, World Health Organization and imposition of vaccines and, prisoners' rights and whatever else we want to make up, it still all comes back to territorial ownership. Because even all of these crazy abstract laws that they're trying to make into international law, they're still between countries with land, right? Even the Vatican, the Catholic Church, there is still a land behind it. The Vatican, It is physical land over which this supreme monarch, Pope Francis, has power. All law comes back to the land, no matter how you look at it. And that's not just for Schmitt, not just for natural law people. That is for Kant and Locke, too, the foundation of modern liberalism. Schmitt is pointing out, even these guys, if you go back to them, they will still tell you that all law goes back to the land. Thus, in some form, the constitutive process of a land appropriation is found at the beginning of the history of every settled people, every commonwealth, every empire. This is true as well for the beginning of every historical epoch. Not only logically, but also historically, land appropriation precedes the order that follows from it. It constitutes the original spatial order, the source of all further concrete order and all further law. It is the reproductive root and the normative order of history. All further property relations, communal or individual, public or private property, and all forms of possession and use in society and in international law are derived from this radical title. All subsequent law and everything promulgated and enacted thereafter as decrees and commands are nourished, to use Heraclitus' word, by this source. The traditional history of international law also is a history of land appropriations. At certain times, sea appropriations also became part of this history, and then the nomos of the earth rests on a particular relation between firm land and free sea. Today, as a result of a new spatial phenomenon, the possibility of a domination of airspace, firm land and free sea alike are being altered drastically, both in and of themselves and in relation to each other. Not only are the dimensions of territorial sovereignty changing, not only is the efficacy and velocity of the means of human power, transport, and information changing, but so too is the content of this effectivity. So he's talking about airspace. Aviation law is another world of law that I'm not going to get into because, quite frankly, I don't know anything about it. But it's its own beast. I'm talking about air rights, going up for a skyscraper, for instance, or zoning. You know, you've got two buildings next to each other, and one building, they infringe on the air rights of another when they build, and it casts a shadow over their pool. Or you got to talk about where airplanes can fly or how high you can fly a drone. All of that is aviation law. All of that's a different subject. And what Schmitt is saying is that dimension of space that was not contemplated in all of our history up until now, that opens a new possibility for a new nomos of the earth. And that's not even counting space exploration. This always has a spatial dimension and always remains an important concept of international law for land appropriations and land occupations, as well as for embargoes and blockades. Consequently, as a result of these developments, the relation between protection and obedience, and with it the structure of political and social power and their relation to other powers, is changing. We are on the threshold of a new stage of human spatial consciousness and global order. Eerie prediction in 1950. All pre-global orders were essentially terrestrial, even if they encompass sea powers and thalassocracies. The originally terrestrial world was altered in the Age of Discovery, when the Earth first was encompassed and measured by the global consciousness of European peoples. This resulted in the first nomos of the Earth. It was based on a particular relation between the spatial order of firm land and the spatial order of free sea, and for 400 years it supported a Eurocentric international law, the Jus Publicum Europaeum. In the 16th century, it was England that dared to take the step from a terrestrial to a maritime existence. A further step was taken with the Industrial Revolution, in the course of which the Earth was newly conceived and newly measured. It was essential that the Industrial Revolution occurred in the country that first had taken the step to a maritime existence. This is the point at which we can approach the mystery of the new nomos of the Earth. Until now, only one author, Hegel, has come close to this arcanum, or secret. His words will serve to conclude this corollary. The principle of family life is dependence on the soil, on firm land, on terra firma. Similarly, The natural element for industry animating its outward movement is the sea. This quotation is pregnant with meaning for further prognoses. For the moment, however, we must consider an elementary distinction, because it is not inconsequential whether the industrialized and mechanized world that men have created with the help of technology has a terrestrial or a maritime foundation. But today, it is conceivable that the air will envelop the sea and perhaps even the earth, and that men will transform their planet into a combination of produce warehouse and aircraft carrier. Then, new amity lines will be drawn, beyond which atomic and hydrogen bombs will fall. Nevertheless, we cling to the hope that we will find the normative order of the earth, and that the peacemakers will inherit the earth. The end of chapter 1. Very optimistic. We do live in the most peaceful age in human history. The question is, for how long? Again, we are reading from the Nomos of the Earth by Carl Schmitt. That is going to conclude our program for today. Next week, we might do chapter 2, or we might do some legal news. I don't know. I don't plan these episodes that far ahead. Actually, I might be on the road next Friday, so we might not have this at all. In which case, we'd check in with you on June 17th. So, one way or the other, we'll see you right back here. Until then, everybody.